You want to live with your husband or wife in the United Kingdom. You thought you knew the rules. You were wrong. The UK spouse visa in 2026 is not the same visa it was 2 years ago. The financial threshold has jumped by 56%. The evidence standards have hardened. Digital immigration status is replacing physical documents. Settlement rules are under direct threat from earned settlement reforms. And from 25 February 2026, even visiting your partner in the UK from dozens of countries now requires an electronic travel authorization before you board the plane. Thousands of couples are being refused, delayed, or blindsided right now because they planned for the old system. This video tells you exactly what the new system looks like, where the traps are, and what you must do before April 2026 to protect your family. The UK Family Visa, officially called the Partner Visa and covering spouses, civil partners, and unmarried partners, is one of the most emotionally high-stakes applications in the entire British immigration system. It is not a route for economic migrants seeking work. It is a route for families trying to live together in the same country. And precisely because of that emotional weight, the consequences of getting it wrong are devastating. A refusal does not just mean a delay. It means months or years of separation from the person you love. It means children growing up without a parent. It means careers put on hold across continents. The UK government has made the spouse visa significantly harder to obtain since April 2024, and further changes are coming in 2026. The financial threshold has risen sharply. Evidential standards have been tightened by caseworkers. Digital immigration systems are replacing physical documents. The earned settlement consultation threatens to reshape what happens after you are in the UK. And a Westminster Hall parliamentary debate on immigration reforms is scheduled for 17th March 2026, which means further developments are imminent. This video covers 7 critical things you must understand about the UK spouse visa in 2026 before you submit your application, extend your stay, or plan your path to settlement. The first thing you must understand is the financial requirement, because this is where the majority of UK spouse visa applications fail and where the most confusion exists in 2026. The minimum income requirement for a UK sponsor bringing a spouse or partner to the UK is currently set at $29,000 per year. This threshold was introduced on 11th April 2024 and applies to all new spouse visa applications submitted on or after that date. It represents a significant increase from the previous long-standing threshold of $18,600 that applied before April 2024. The proposed further increase to $38,700, which generated enormous public alarm and controversy in 2023 and early 2024, has been paused by the current government. The Migration Advisory Committee published its report in June 2025, following an independent review commissioned by the Home Secretary, but it did not recommend a specific new threshold. No confirmed timetable for further increases has been published. So the position as of right now is clear. $29,000 for new applications, $18,600 for transitional applications, and no confirmed increase beyond $29,000 in the foreseeable future. However, there is an absolutely critical transitional arrangement that many couples are getting wrong. If your initial spouse visa application was submitted before 11th April 2024 and you remain on the same route, your extensions and your eventual settlement application will continue to be assessed against the old $18,600 threshold, not the new $29,000 level. This protection is powerful, but it is not automatic. If you switch routes, change your immigration status in a way that breaks the continuity of your spouse visa route, or fail to correctly evidence the transitional arrangements in your next application, you could lose the protection and fall under the $29,000 requirement. Every couple whose original application predates April 2024 must get specialist legal advice before their next extension to confirm exactly how the transitional rules apply to their specific situation. Getting this wrong could mean being assessed at a financial threshold that is 56% higher than the one you planned for. The second important point covers who counts as the sponsor and what income sources are acceptable. The sponsor must be either a British citizen, a person with indefinite leave to remain, someone with settled status under the EU settlement scheme, or a refugee or person with humanitarian protection in the UK. The financial requirement is assessed primarily by reference to the sponsor's income, not the applicant's income if the applicant is outside the UK. The Home Office accepts income from multiple sources, and these can be combined to meet the $29,000 threshold. Employment income from a permanent or fixed-term contract is the most straightforward route, evidenced through 6 months of pay slips and corresponding bank statements covering the 6 months immediately before the application. Self-employment income is equally valid, but requires significantly more documentation, including tax returns, business accounts, and evidence of ongoing trading. Non-employment income, including pension income, rental income, and investment income, can also count, but each category has its own specific evidential rules under Appendix FMSE of the Immigration Rules. There is also an important savings alternative. If the sponsor cannot meet the income threshold through earnings alone, cash savings can be used to top up to the required level or meet it entirely, but the savings must be held in a financial account for a minimum of 6 consecutive months before the application is submitted. This is known as the 6-month savings rule, and it is one of the most commonly misunderstood requirements. Many couples start saving the moment they decide to apply, not realizing they must then wait 6 full months before those savings count. There is also a specific exemption for sponsors who receive disability-related or carers benefits. These sponsors are assessed under the adequate maintenance test rather than the fixed income threshold. This exemption is frequently overlooked and can make the difference between eligibility and ineligibility for certain families. The third critical area is the English language requirement, because there is widespread confusion in 2026 about what has changed and what has not. The position for UK spouse visa applicants in 2026 is as follows. For a first-time application from outside the UK, the applicant must demonstrate English language ability at CEFR level A1 in speaking and listening. This is a basic conversational level requirement, tested through an approved secure English language test from a provider on the Home Office approved list, such as IELTS Life Skills A1, Trinity College GESE Grade 2, or Language Cert. The test result is valid for 2 years from the test date. Exemptions apply if you are a national of a majority English-speaking country, a list that includes the United States, Canada, Australia, New Zealand, Jamaica, and several others. Exemptions also apply if you hold a degree that was taught entirely in English and is deemed by UK ENIC as equivalent to a UK bachelor's degree or higher if you are aged 65 or over, or if you have a disability that prevents you from taking the test. For an extension application, a higher level of A2 is required if you have already been in the UK on the spouse visa route for at least 30 months and are making a further leave to remain application. There is an important clarification to make here. Some recent media reports and social media posts have incorrectly suggested that B2 English is now required for spouse visa applications in 2026. This is inaccurate. The B2 requirement applies from 26 March 2026 to new applicants on the skilled worker, scale-up, and high-potential individual routes for settlement purposes, not to spouse visa applicants. The spouse visa English language requirements remain A1 for initial entry and A2 for extension. This distinction matters significantly for anyone planning a spouse visa application in 2026. The fourth point covers the relationship evidence requirements, which have become dramatically more demanding in practice, even though the legal standard has not changed on paper. The legal requirement remains that the relationship must be genuine and subsisting, but Home Office caseworkers in 2026 are applying significantly higher levels of scrutiny to relationship evidence than they were 2 or 3 years ago. Applications are increasingly refused where the evidence bundle is poorly organized, lacks a clear chronological timeline, contains gaps without explanation, or relies too heavily on formal documents like marriage certificates without supporting personal evidence. What works in 2026 is a comprehensive, well-structured relationship timeline that includes communication records such as call logs, message screenshots, and email correspondence, travel records showing visits to each other, photographs across multiple years and occasions, evidence of shared financial commitments, references from people who know you as a couple, and a detailed personal statement that addresses the specific concerns a caseworker might raise about your relationship. If you live in different countries and have never cohabited, or if your relationship has been conducted primarily online, you need to work especially hard to demonstrate that the relationship is genuine, ongoing, and has substance beyond a formal legal status. The fifth important area for 2026 covers the digital immigration system and the transition from physical biometric residence permits to eVisas. From 2026, all UK immigration permission is being converted to digital records held in the Home Office's UKVI database, accessed through a UK Visas and Immigration online account. Physical BRP cards issued to spouse visa holders and their dependents are no longer being replaced when they expire. Instead, holders are directed to access their immigration status digitally through their UKVI account. This transition has caused significant practical problems for many migrants. If your UKVI account details are incorrect or out of date, if your account is linked to an old passport number and you have since renewed your passport, or if you have any technical issue with your online account, you may not be able to prove your right to live and work in the UK when employers, landlords, or border officials check your status. From 25 February 2026, airlines, ferry operators, and international rail services are legally required to check your digital immigration status before allowing you to board. If your digital record is not properly linked to the passport you are traveling on, you may be denied boarding. Every spouse visa holder in the UK must ensure that their UKVI account is current, that it is linked to their current passport, and that they can successfully access and share their immigration status online before any international travel. The sixth point is about what happens to settlement after 5 years on the spouse visa route and why 2026 matters for long-term planning. The confirmed position as of today is that spouse visa holders and immediate family members of British citizens are expected to retain the 5-year route to indefinite leave to remain. The wider earned settlement proposals that would double the qualifying period from 5 to 10 years for most work visa migrants are not expected to apply to the spouse visa route for partners of British citizens. The 12,570 individual earnings requirement that has been proposed under the earned settlement consultation for certain migrants does not apply to spouse visa applicants. However, there are new suitability checks being applied to ILR applications in 2026. The Home Office is conducting stricter reviews of criminal records, outstanding government debts, and compliance with immigration conditions when assessing settlement applications. Any immigration breach, any conviction, any period of overstay, or any non-compliance with the conditions of your visa during the 5-year qualifying period could result in a refused ILR application. The absence of the 10-year extension for the spouse route is important protection, but it does not mean the route is without challenge at settlement stage. And you must still meet the continuous residence requirement, which means you cannot have spent more than 180 days outside the UK in any 12-month rolling period during your qualifying 5 years. Every trip abroad during your qualifying period must be carefully tracked and evidenced. The seventh and final point covers the application process itself, the costs, the timeline, and the most common and entirely preventable mistakes that lead to refusals. The current application fee for a UK spouse visa from outside the UK is $1,946. For an in-country further leave to remain extension, the fee is $1,258. The immigration health surcharge must also be paid upfront for the entire period of the visa at $1,035 per person per year, meaning that a 33-month initial spouse visa costs an additional $2,587.50 in surcharge alone. A refused application does not automatically refund these fees. You have the option of an administrative review if you believe there was a caseworker error, or an appeal to the first-tier tribunal on human rights grounds if the refusal engages your right to private and family life under Article 8 of the European Convention on Human Rights. Applications from outside the UK are processed in most cases within 12 weeks, though the Home Office offers priority services for additional fees. Applications from inside the UK under further leave to remain are similarly around 8 to 10 weeks for standard processing. The single most common preventable mistake is insufficient financial evidence, specifically the failure to provide both payslips and corresponding bank statements for the full required period. The second most common mistake is inadequate relationship evidence, where couples provide formal legal documents but insufficient personal material. The third is failing to account for transitional arrangements and applying under the wrong financial threshold. And the fourth is submitting an application when the sponsor's income has only recently reached $29,000 and has not been stable for the required evidential period. The UK spouse visa in 2026 is not impossible. Thousands of couples successfully navigate it every month, but it demands precision, preparation, and an understanding of exactly which rules apply to your specific circumstances, your specific timeline, and your specific financial situation. The couples who succeed are not the ones who earn the most or who have the most glamorous relationship story. They are the ones who understand the requirements, prepare their evidence meticulously, and submit applications that make the case worker's decision easy. The couples who fail are the ones who guessed, who relied on outdated information, who tried to save money on legal advice for a process that costs nearly $5,000 in fees and represents years of their lives. Do not be in the second group. If you are planning a first-time application, speak to a regulated immigration solicitor before you start gathering documents, not after. If you are coming up to an extension and your original application predates April 2024, confirm your transitional position before your current visa expires. If you hold a BRP card and have not yet accessed your eVisa account, do it today. And if your UKVI account is not linked to your current passport, fix that before your next trip outside the UK. Share this video with every couple you know who is navigating the UK spouse visa process. The information in this video could save them months of separation, thousands of pounds in avoidable refusals, and years of unnecessary uncertainty. Leave your questions in the comments. Subscribe to this channel for every update on UK spouse visa and immigration rules throughout 2026 and beyond. Your family deserves to be together. Make sure the paperwork does not get in the way.